Good afternoon, everyone, and I want to thank you for joining us for our first session of this season, an overview of Ohio civil rights law and changes with House Bill 352. This session has been approved for 1 hour CLE. So for those attorneys looking for CLE credit, we're asking that you sign your name and your registration number. We will provide a copy of the PowerPoint presentation through the chat feature, so please feel free to download that. Our speaker is Administrative Law Judge Denise M. Johnson. ALJ Johnson has held the position of Chief Administrative Law Judge for the Ohio Civil Rights Commission since May of 2005. She has been a guest speaker on issues related to employment, housing, and public accommodations for a wide variety of employment agencies. She's also had a prior life been an in-house counsel for Huntington National Bank, chief of the Civil Rights Section of the Attorney General's Office, and staff attorney for the Attorney General's Office in both the Civil Rights and the Charitable Foundations Section. I do share with you ALJ Johnson. I am also an alumni from Capital University, but I also have another alumnus here that wants to speak on, make some personal comments about you, and that's Don Collins, sorry.
All right, thanks. Thank you, everybody. I'm glad to be here, and I note we have a bunch of familiar faces as well as a few new folks, and I see that CERB is well represented here, so that's very cool. During the course of our careers, mine and Denise's, we've crossed paths on a number of occasions at the Attorney General's office and in other places. But the real reason I wanted to talk today is that, or make a comment before I turn this over, is that Denise and I started law school on the same day, way back in 2006. Is that right, Denise? It was a little bit before that.
A little bit less.
Nevertheless, Denise is a consummate professional and one of the experts in employment and civil rights law in the state of Ohio. And it has been my pleasure to have worked with her and know her over the last several years, more than several years. And I ask that you all, say the same about her. And let's listen to what she has to say. New law regarding civil rights claims and how you go to court. So with that, I'm turning it over to Denise.
Thank you for your gracious introduction, Mita, and to you, Don. Yes, we do have a long history of knowing one another and in our professional lives, and it's been great. I'd like to start off by saying that Ohio has gone through a lot of maybe not a lot of changes. In fact, the reason uniformity law is because attorneys have been trying since 1999 to get new legislation passed in terms of making Ohio's employment law uniform. There were issues with lawsuits to be filed under Revised Code 4112/99 as it existed before House Bill 52. Arising under 4112 could file multiple claims simultaneously in state and federal court, and also have their claims existing in the administrative forum before the Ohio Civil Rights Commission. There were a lot of employment defense attorneys that just thought this was just untenable, that it did not track with the way federal law, individuals who had claims arising under Title VII could. So the goal was to be able to have a way of tracking the number of discrimination claims brought in the state of Ohio. So now what this new Ohio law does is to make an exhaustion of remedies requirement. that first individuals must file with the Ohio Civil Rights Commission that feel aggrieved under revised code 4112. That is in employment cases, just applies to employment cases because the Ohio revised code 4112 also addresses discrimination complaints in housing, public accommodations, discrimination against the disabled in higher institutions of higher learning, discrimination against females in regard to credit. It's broader than just employment, but since this this focus is employment discrimination, we'll be just talking about employment law.
ALJ Johnson, may I briefly interrupt?
Yes.
We're getting a garble effect. Maybe if you turn off your video, that may help.
My video?
Yes.
Okay.
I think your internet might be unstable.
Probably so.
With this rain, you know, you don't.
Could be, that's right. If it has anything to do with, I'm sorry. If it has anything to do with, sorry. Let me turn it off. Stop my video.
Am I
There it
correct?
is. Okay.
That can,
Can you hear me better now? The less garbled?
Yes. And
Okay.
also your slides are not advancing.
So let me see if I can't start them. Okay. Want to start off by saying that the commission is an agency that's created to investigate and assess allegations of discrimination, including employment discrimination, our focus today. That the OCRC does not represent the person filing the charge or the employer. I think that gets sort of lost in the mix of things because lots of times employers feel that the Ohio Civil Rights Commission represents the charging party who feels aggrieved under 4112, but the commission does not. It is an independent, neutral law enforcement agency. And its investigations are looked at, the lens of its investigation is through a neutral law enforcement lens. And the OCRC has jurisdiction over places of employment that have 4 or more employees. I also have to state that after 17 years of leadership by G. Michael Payton, then Angela Phelps White is our executive director. She had the daunting task of becoming our executive director the week that that she onboarded, the week that we were told that we had to telework because of the pandemic. So it was quite an accomplishment for her to onboard during such a turbulent period of time. And at the same time, to have to deal with implementing this new legislation in terms of how it affects the commission's administrative processes. So we're moving along, and I really have to say that things are moving well, at least from my perspective. But it's hard to tell. We won't be able to tell much because we need some time to see some trends. And so again, the structure of the OCRC, it's the legislative authority is pursuant to revised code 4112. The body that makes determinations of that has the final say in whether or not to issue complaints of discrimination is are the commissioners, and there are 5 of them appointed by the governor. They meet publicly every 3 or 4 weeks, and there are 5 regional offices. Now, House Bill 352 became effective, as I said, on, well, I didn't say this, but on April 15th of 2021. It, as I noted, has an exhaustion of remedies requirement before a charging party can request a notice of right to sue. And it's just the acronym for that, we call it a NORTS. A new section was created just to deal with employment discrimination claims. That new section is Ohio Revised Code 4112.051, and Ohio Revised Code 4112.052 replaces 4112.99, which was the section that individuals who wanted to go to court used to initiate actions, civil actions in court other than administrative remedy. The age election language changes to a conditional filing structure similar to other classes. So prior to 352, there were so many amendments to Revised Code 4112 that there were different standards for age discrimination cases in terms of the filing, in terms of damages or remedies. So House Bill 352 brought the age discrimination claims in compliance, or not compliance, but in conformance with not having so many bases to be able to file an age case, but to streamline it. Oops. So if the OCRC fails to issue a NORTS to a charging party when they request it, and we'll talk more about that, or when the commission makes a PC finding, then those are the only two times that the charging party can go to court without first receiving a notice of right to sue. In an age discrimination claim, an individual can go straight to court without a NORTS if they want injunctive relief only. Oh, sorry, let me go back here. Another change is that there's two-year statute of limitations now. It used to be 6 years. Employers complained about evidence getting stale. It was probably one of the only states in the United States that had such a long statute of limitation for employment discrimination claims, and that was changed. And so the statute of limitations to file a claim or a charge with the Ohio Civil Rights Commission is 2 years and not 6 years. The only exception, and I'll talk about that in terms of waiving that 2-year statute of limitation, is if someone waits until 60 days before or less or longer than 60 days before the 2-year statute of limitations to file a charge of discrimination with the commission. But the commission must issue the NORTS to an individual if they request it within 60 days after they request the NORTS. If the commission fails to do that after 60 days, then add it on another 45 days to that, which is a total of 105 days, the charging party can go straight to court without actually receiving the NORTS from the commission. The House Bill 352 also removed liability for managers and supervisors from being included in the definition of employer. The definition now only says agents instead of a person in terms of who could be exposed to liability for violating the law in terms of discriminating against someone in their employment. So again, the definition excludes any person acting directly or directly in the interest of an employer, and now says agents. So no person, but an agent. Again, statute of limitations period is 2 years for filing a claim. I got asked a question at one forum, what if before someone had a charge of discrimination that they could have filed before the law was enacted, before April the 15th. And it would take them, if they were out of jurisdiction for the statute of limitations, which was no, they were out of jurisdiction for the statute of limitations. No, I'm being confusing. Let me straighten this out. Let me talk about the commission's statute of limitations for filing a charge of discrimination. The commission's statute of limitations for an individual who files a charge of discrimination, and the commission's requirement that they make a recommendation is a year. They have a year to investigate. They have a year to make a recommendation, but the individual no longer has to file the charge with the commission within 6 months of the discriminatory conduct, of the alleged discriminatory conduct. The commission now, the charging party, can file a claim within 2 years. 2 years statutation limit, excuse me, the 2-year statute limitation requirement applies to charges filed with the Ohio Civil Rights Commission. So an individual has 2 years to file a charge of discrimination with the Ohio Civil Rights Commission, who is alleging discriminatory conduct. The individual also has 2 years to file a charge of discrimination, or excuse me, a complaint of discrimination in court. So that goes back to another aspect of the statute that says that if an individual files a charge with the commission within 60 days of the statute of limitations period, then the commission will, the 2-year statute of limitation period for filing in court is waived until after the charge is no longer pending with the commission. If the, and this is really confusing, it took me a long time to figure this one out. If it's 60 days is the point that you want to look at, if it's less than 60 days that the commission, that the individual files a charge with the commission, then when the charge is no longer pending, and the commission says the charge is no longer pending when there is no longer a final appellable order, then that individual must file within 45 days after the charge is no longer pending. That one's confusing. So here we go. Statute of limitation told for filing civil suit, less than 60 days. Oh, I gave you a wrong time. I should have looked at my presentation to be more accurate. So statute of limitation is told for filing civil suit. And that is, again, remember, an individual can file a charge of discrimination no longer 6 months from the date of the alleged discriminatory conduct. It's 2 years. So the statute of limitation is told for filing a civil suit if they want to go file a civil suit. If they file the charge within 60 days, less than 60 days before the statute of limitation, the date filed to the date 60 days after the charge is no longer pending. And if they file the charge more than 60 days before the statute of limitation period is up, then it's the date filed until the date that the charge is no longer pending. Also, the statute codified the Farragher-Ellerer affirmative defense that employers have in regards to sexual harassment claims, hostile work environment. If the employer has a policy in place that allows for individuals who feel that they've been subjected to hostile work environment, sexual harassment, and the individual does not take advantage of the process that's in place, then that is an affirmative defense that employers have, is codified. Now, it was applied before that through case interpretation, but now it's codified under Ohio law. The other thing that you'll see in terms of what's different with the commission in terms of its intake process because of the changes brought by House Bill 352 is that we want to find out, the commission would like to find out what the charging party's intent is when they file. Do they intend to request a right to sue letter immediately? Do they intend to request that? If they planned to attempt mediation and request a notice of right to sue if it's unsuccessful, and the some of the process behind and some of the thoughts behind how this will help the employers and employees is that we may have more attempts to mediate through the OCRC mediation process or attempts to settle. If the employer has notice before of the charges of discrimination, other than just getting a letter, a warning letter from an attorney that they've gone to see, then the thought was that that may give more opportunity to seek mediation and conciliation or settlement of the issue so that you have fewer claims going to court. So this, unfortunately, this new addition to the intake process is not going to be something that is available to employers. That the commission has taken the position that this new intake information that may be provided by charging parties is a part of the investigative process. And until the commission makes a determination of probable cause, no probable cause, then anything that's done during the commission's investigation is private, it is confidential. So again, there will be an additional page with the employment charge to indicate whether CP, that's the charging party, intends to only pursue mediation or NORTS. CPs can change their mind. Based on that form, the cases then are triaged as A, B, or C classification. The A classification, based on the information that's gotten at the time that the investigation intake process starts, is whether or not there needs to be a full investigation based on the intent, the stated intent of the charging party. The B is you can't get really clear information whether they want to or whether they don't want to. They're sort of sitting on the fence. So those are then B is signified or classified as B. And those are ones that the commission goes to takes the position that they'll ask for a position statement from the employer or do an expedited investigation. And the C category is where people want to just mediate and do and then have a request to sue, a NORTS. Again, I said that mediations are expected to increase and that what happened before 352 is that the mediators were very willing and very flexible to consider everyone's calendar and schedule. But with the anticipation that mediations may increase as a result of House Bill 352, then the mediators may not have that luxury to be so flexible with their own schedule if if they have more mediation requests coming in. So just things for you to look for and anticipate. What happens when the with the EEOC dual file charge. For people that don't know, the Ohio Civil Rights Commission is an agency that has a work sharing agreement with the EEOC, so that the work sharing agreement says when the charge is filed with one, is filed with the other. So charges filed with the OCRC will be dual filed if they meet the following criteria. If it's an employment related charge, if it's filed within 300 days of the date of harm. So for the EEOC to have jurisdiction for people who want to file claims under Title VII, they don't have 2 years. They have 300 days. The claim falls under Title VII, the ADA, ADEA, EPA, or GINA, and that the employer has a maximum, a minimum of 15 employees, 20 for the ADEA. And that's the Age, Discrimination, and Employment Act. Let me stop here and ask anyone if they have any questions about what I just went through very quickly. Any questions? Before I go to the employment, and when I talked to Mita, she said people were interested in talking about prima facie case and what you might expect as a employer if a charge or claim of discrimination is being pursued, or someone is complaining about discrimination and looking to go and have it resolved outside of the agency. So that's what this next section is. So I started out by saying Ohio is an employment at will state, which means that employee can be disciplined or terminated for a good reason, a bad reason, an ill-informed reason, a reason based upon incorrect facts, or for no reason at all. However, an employee cannot be terminated for an unlawful reason. So against whom may a charge be filed? Under Ohio law, an employer of 4 or more persons. Labor organizations, a file can be charged against labor organizations, and a file can be charged against employment and temporary agencies. So for employers, what should you do if a charge is filed against you or your department? Contact and work with your EEO department. That's a good recommendation. Cooperate with the commission. Remember that it's a neutral third party. Keep in mind that the purpose of the investigation is to see if there is evidence supporting the allegations and whether the explanations given by the employer are supported and or consistently to apply to all employees. And do not retaliate. So I addressed what a prima facie case of retaliation is in this training. But let me talk about the OCRC investigative process, give you a little what actually in a more granular sense happens once the investigator gets a hold of a charge affidavit. The charge affidavit is received, and it can be received by the commission, mail, online, referral, in person. I was also interested to find out that the charge, it doesn't have to be on a form provided by the commission. It can be one that's written but contains all of the information that's required for the commission to determine whether it has jurisdiction over that charge. After that, the case is assigned to an ABC designation, as I've indicated. The perfected charge is assigned to a lead investigator. And what do I mean by perfected? A perfected charge is one where, among other things, in terms of information, right now there's a requirement that the charge, an employment charge, be under oath. So the charge is not perfected until it is signed under oath by the charging party. Once that happens, the investigator who is assigned the case meets with a team. An investigative plan is created. Then the respondent is served with a copy of the charge affidavit and asked to respond to specific allegations in the charge. That's the That's known as the position statement that the commission is seeking from the employer. If the charging party has not requested a NORTS, as we saw in category A, then this would be the case where a category B case under employment, where the charging party is not quite sure where they want to go with it. Then the commission is going to be asking for a position statement. And in that position statement, the commission asked the respondent for information and documents. Respondent and complainant may be invited to participate in mediation. Also, that's part of this whole investigative process. The complaining party is informed of respondent's position and informed an opportunity to provide a rebuttal. And witnesses are contacted, documents are reviewed. That's really generally what goes on during the commission's investigative process. Prima facie case. I think Mita said, oh, they'd like to know about the prima facie case and employment discrimination. What makes the basis for a prima facie case of a claim of employment discrimination? Sorry. So prima facie is a Latin term that means on its face or at first glance. And in order to make a determination of probable cause, the commission must have enough evidence to make a prima facie case of discrimination. In other words, the charging party's evidence must be enough for the commission to infer, absent direct evidence or statutory, and it was the employer shall do something. That's shall means that's a mandate. That discrimination took place based on race, color, religion, sex, national origin, ancestry, disability, age, or military status. After the commission has sufficient, has sufficient evidence to establish a prima facie case, the employer must present evidence of a legitimate, non-discriminatory motive for the employment decision at issue. The charging party then has an opportunity to challenge the commission's evidence by showing that the reasons given for the decision were a pretext for discrimination, and pretext is not true, not the true reason. But under applicable law, just because something is not true doesn't mean that it was motivated by a discriminatory animus. That's the other standard, is that the decision, whether it was, even if it was not true, the commission must still prove that the decision of the employer and the adverse action that took place as a result of that was based on a discriminatory action. So after the commission has sufficient evidence to establish a prima facie case, the employer must present evidence of a legitimate, non-discriminatory motive for the employment decision at issue. The charging party then has an opportunity to challenge the commission's evidence by, I'm sorry, that's wrong, not the commission, but the employer's evidence by showing that the reasons given for the decision were a pretext for discrimination. So let's go down the line here. What's a prima facie case of age discrimination? What evidence must the commission establish to show that, absent an explanation from the employer as to why the adverse action was taken, that the commission then infers that the reason behind the adverse action was because of that person's protected status / age. So that would be the charging party with a member of a statutorily protected class, that in terms of their age, that's the class here. CP was qualified for the position. The charging party suffered an adverse action, and the charging party was replaced by, or the discharge permitted the retention of a person substantially younger, or CP suffered some other adverse employment action. Let's talk about race, sex, national origin, and ancestry in order to, and this is disparate treatment. the ways in which discrimination cases are proven is through direct evidence. That is, there's no doubt about the motivation behind the what motivated the employer to take the adverse action against the employee who is in a protected class, whether it be statements like, no, women can't do this job, or, a Black person's incompetent to do the job, or, I don't believe that an immigrant has can fully engage and become a part of our workforce. Those are some extreme examples, but those are examples of direct evidence of discrimination, discriminatory intent or motive. So to establish a prima facie of discrimination on the basis of race, sex, national origin, or ancestry, the charging party has to show they are a member of a protected class, that they were performing the job satisfactorily and they were qualified, that despite the qualifications that the charging party suffered an adverse employment action and the charging party again was replaced by a person outside the protected class, was treated less favorably than a similarly situated individual outside of the protected class. And we call treated less favorably than similarly situated individuals outside the protected class. We look at those individuals as comparables, people who have the same job, the same supervisor, and engaged in the same conduct as a person who's in a protected class, but was treated less favorably than that person who is a comparable. I also wanted to say that in terms of claims of discrimination, there's sexual harassment, which I don't think I need to define. You can see what sexual harassment is defined there. And sexual harassment comes in two forms: quid pro quo sexual harassment, which is submission to a rejection of conduct, and it's used as a basis for an employment decision by the alleged harasser. Or for a hostile work environment, you have unwelcome comments or conduct that have the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating or offensive work environment. Now, if this is a coworker, then this is where the Farragher-Ellerith defense comes into place. If the employer has a policy, a procedure in place for the person who is alleging that they're being subjected to a hostile environment based on their sex, that they can pursue this claim and have it investigated and resolved through that process. For disability discrimination, to establish a prima facie case of disability discrimination, the evidence has to show that the charging party is disabled. And that definition of disabled under RC 41-1201, it used to be a higher standard that had to be met before the passage of the ADAAA, but it's not as, you don't have to be so disabled that you can barely work in order to meet the definition of disabled under 41-1201 or under Title VII. So the charging party is disabled and respondent has actual knowledge of the disability. Oops, I am sorry I keep doing this. I don't know why I'm doing this like this. He has actual knowledge of the person's disability. The employer perceives the person as being disabled, even though the person is not actually disabled and doesn't need an accommodation for their disability, that the employer treats them like they are disabled, or that the person has a record of a disability, that there's a known record of the person having some sort of condition that the employer then views as that person having a disability, that the charging party suffered an adverse employment action, at least in part because he or she was disabled. I'm sorry. And the charging party can safely and substantially perform the essential functions of his or her job despite the disability. Let's talk about disability reasonable accommodation. And a reasonable accommodation you may see a lot of in the workplace because the ADAAA and the ADA requires that the employer, people hate the word affirmative action, but it does require the employer to act in a manner that they provide something that they don't have to provide everybody else. So it's not equal treatment. It's accommodation is to allow for disabled individuals who can do the job with or without some reasonable accommodation. The ability to work within the with employers, have a job, to be like anyone else who is not disabled and wants to work. So they have to be disabled within the meaning of the act, that they're other qualified for the position with or without reasonable accommodation, that the employer knew or had reason to know about the disability, and that the employee, here I go again, that the employee requested an accommodation and that the employer failed to provide the necessary accommodation. And I'll have to say that when it comes to reasonable accommodation cases, this is very scant. There are multi-layers in a disability accommodation case, but that is the basic prima facie case in a disability accommodation case. So then if the employer's acts remain unexplained after, during the investigation, that's not, of course, going to happen once the file a claim goes to the resolution stage, which is either a civil suit or through the commission's administrative process. If the employer's actions remain unexplained, then it's more likely than not that the actions were based on a legal discriminatory motive. But again, there's a reality check. Most employers will explain for the basis for their actions. When a case is being resolved pursuant to an adversarial proceeding, whether it be a civil action in court or the administrative forum, a burden shifting analysis is applied to who has the burden of proof. The OCRC has the burden of establishing a prima facie showing of discrimination. The employer must then articulate a legitimate non-discriminatory reason for the adverse action. So the plaintiff, this will be the OCRC, has the burden of proving that the reason was a pretext. So the burden of production, of going forward, and of proof of the discriminatory conduct that the employer's articulated reason with a pretext is upon the OCRC / the plaintiff. What is the employer's burden? Only to clearly articulate its non-discriminatory reason. It does not have to persuade the fact finder that it was actually motivated by the proper reason. It's up to the commission or to the defense attorney, the plaintiff's attorney. That's who the burden falls on to prove that the decision was actually motivated by the proffered, I'm sorry. It's up to the plaintiff or the commission. And I will say this, I keep saying the commission because remember, you'll have to remember that when the commission issues a complaint, it's resolved through the administrative process. It is the commission's complaint. And the commission has the statutory goal to eliminate discrimination in the state of Ohio. So the commission it's the commission's complaint, the commission is a party, but say, for example, the key witness in the commission's complaint is the charging party / complainant once it gets to the hearing phase. And in the commission proceeding, the Attorney General represents the commission's complaint and puts the evidence in on behalf of the commission's complaint. That's why I said the complainant in the administrative forum is the key witness for the commission in terms of eliminating complaints of discrimination in the state of Ohio. How does one prove pretext? They have to demonstrate the reason is false, that was not the actual reason, demonstrate inconsistency, showing that the reason is not believable, demonstrating that similarly situated persons not in the protected class receive more favorable treatment. Who is a comparable person? To be a comparable person, the person must be extremely similar to the charging party in nearly all respects. The comparable must have the same supervisor, have the same job, have engaged in the same activity that caused the adverse action, have been treated better than the charging party for the same activity. Is proving pretext enough? No, as I said before, the plaintiff must still prove that the real reason is based on one of the unlawful categories prohibited by law. What's retaliation? Retaliation is an adverse action taken against an employee because that employee has engaged in a protected activity, whether they've, and the protected activity, it can be you filed a charge with the discrimination, with the House Civil Rights Commission, or you filed you didn't necessarily have to file a charge. You could have participated as a witness in a commission investigation, or you could have approached the employer in some way, shape, or form or fashion and complained to them that you felt that you were being treated adversely because of your protected status. So protected activity is not confined to filing a charge or participating in an investigation of a charge. It also encompasses what you may have put your supervisor, your manager, the employer on notice about in terms of your belief, your good faith belief that you have been discriminated against based on your protected status. So again, it's a protected activity and it occurs when an employee has reported discrimination or has participated in a discrimination proceeding. For example, a person engages in protected activity when they report discrimination to a supervisor, file a charge of discrimination, act as a witness, all the things that I said before, so I'm going to speed on. Prima facie case of retaliation, employee engaged in a protected activity. The employer knew of the protected activity. That's important. They have to know of the protected activity, and that there's an adverse employment action, and that a connection between the protected and there's a requirement in the prima facie case of a connection between the protected activity and the adverse employment action. So things that are considered as the amount of time between when the person engaged in the protected activity and when the adverse employment action occurred, or the amount of time that occurred between the comments that were made and when the adverse employment action occurred. And the examples are not limited to those two things, but those are just a couple. So cases of discrimination, they can be resolved at the charge stage through mediation, which I've said before. The commission's mediation process is of no charge to the parties. Mediation is voluntary, and it's really a win-win situation if you could resolve the complaint and not continue in an adversarial posture. But if an impasse occurs, then the charge is then referred to the investigator for full investigation. So, any questions?
Hey Denise, this is Don Collins.
Hey,
As a practical matter, individual liability is done away with. Is that correct?
Yes,
Okay,
yep.
so you can only sue the employer and dealing with that. And punitive damages are gone away as well, or?
Well, let me say this, we're talking about the commission's process as opposed to what the civil, like, I can answer that. Damages in a civil action now under, as after 352 in employment discrimination cases are capped. They're considered and defined as torts now. So they meet the torts cap limitation for damages. In a civil lawsuit in employment discrimination cases, then you can still get all the damages that you get before. They didn't eliminate any of those, Don. But there's the caps. You can get attorney's fees. If you go and have your case resolved through the commission and an employment discrimination claim, the damages that can be awarded by the commission are make whole, putting the person back in the position they would have been but for the discriminatory conduct. So that would be back pay, which would include benefits, or in some cases, in some rare cases, front pay, when front pay might be awarded in situations where there's just not a possibility of the person going back in that environment. It was too hostile, it was a case of terrible sexual harassment, things like that. So.
Okay. Thank you.
Other questions?
Denise, I have a question.
Okay.
What are some examples of the effect of unreasonable interference with a person's workplace?
Unreasonable interference. Okay, in terms of
Proving a prima facie case.
are you talking about hostile environment?
Yes.
Okay. A hostile work environment, a hostile work environment can be based not only on sex, but on race. And I'm talking about sexually, like sexual harassment in terms of either quid pro quo or sexually hostile, where sexually hostile based on sex is you as the employer or the employee who is allegedly engaging in that, the perpetrator, I'll call them, that they are making you feel uncomfortable, unwanted. So with sexual harassment, quid pro quo, or based on sex, where what's being sought is sex in exchange for a favor, or that the person in the workplace is sexually attracted to the other person and is bothering them, making them feel uncomfortable. That's one form of hostile environment, where you may have a coworker who is sexually attracted to you. And but then there is another form of hostile work environment based on sex, where the employees may not just want you there. And this happens in workplaces where there are, say, for example, few women in the workplace, as an example. And it's a male-dominated workplace, like in construction or things like that. So instead of harassment being based on because you're a female and I'm sexually attracted to you, the harassment, hostile environment is based on because we don't want you here. We don't want you female in the workplace. And that same kind of hostile environment that I'm talking about can apply in race cases, where there may be not very many African Americans or people who are in a protected status, and people who are in the dominant class will make it uncomfortable for the person who is a protected class to work in that environment, saying derogatory things, hanging nooses, or showing nooses, writing things on the insides of bathroom stalls, like "Go away, we don't want your kind here." And I'm only saying that because we've had cases like that. So is that?
Yes, it does. That's helpful.
Okay.
Can you turn back on your video? Because now that we stopped sharing,
Okay.
we can hear
Sure.
you better now.
Okay, great. Where am I at? Turn my video. Here we go. Okay, here we
Okay.
go. All right. So, yeah. Questions?
We had asked the group, was there any type of best practices that they're aware of? Can you share any?
For
the
me,
workplace?
best practices, I think first of all, you have to be aware of individuals, the employees' rights in the workplace. Don't be indifferent to that. That's a huge best practice thing, is knowledge. And also, I say this about implicit, people talk a lot about implicit bias, but I'm a believer in implicit bias, that that thing that we aren't very consciously aware of exists within our subconscious mind. And it's a part of the way in which we are acculturated, in the way that we've been raised, what we've been exposed to as from a young, very young person. And we're not always aware that the biases that we may have, that we don't think we have, because if studies have been done by that say that people who say, "I'm not biased, I don't have any bias bone in my body, I have lots of friends that are this and that and other thing." But I think our reality is, in this country, is that we all have biases of some sort. And especially for me as a neutral decision maker, when I sit down and I'm conducting a hearing, it's very important for me to make sure that I'm objective and neutral in trying to determine what the facts are, and that I become aware that if I have any sort of a knee-jerk reaction to the person immediately when I see them, because I've sort of, I do my own profiling, that I get rid of that. That's important, but that's something that we all have to consciously work on. You have to make a conscious effort to do that. Mita?
Thank you. Well, do we have any other questions?
One, I'm just trying to type it in, but Ms. Johnson, do you find at hearings, people who may tell you that they're not biased, you were saying, one of my friends happens to be whatever, as an excuse that they're not biased. But do you find that it's harder for those people to admit that they are biased or come to that conclusion during a hearing? And is it your responsibility to try to get them to expose that, or is that the other side's burden?
I'm in a no judgment zone at the hearing. I'm just listening to the testimony, okay? And I'm listening to the testimony. I'm assessing the credibility of the witnesses to determine who I believe in terms of what the facts are going to be to support the allegations of the complaint, or the defenses of the defense of the employer or the respondent to the claim being. So that's why I said I'm in no judgment zone. It's really about the facts. Are the facts there to support the claims in the commission's complaint? has the commission met its burden of proof? You know, because again, from the presentation, the commission has the heavy burden here, the burden of production, moving forward, and persuasion. And so but in terms of implicit biases, I myself had checked myself, but I'm saying to other people and to managers and whatnot, when it's important for you to show your workforce that you're treating everybody, you know, equally, because that's the goal of the anti-discrimination laws, is equal employment opportunity, treating people equally, evaluating them on their merits. You know, we're not, and making sure that's what you do.
Yeah.
So I don't know if I
Thank you.
answered your question, but you know, that's my response to the question you asked me.
Well, thank you.
All right.
Are
Anything
there any other questions? I guess it means a no.
No.
ALJ Johnson, I want to thank you. I think it was highly informative. I walked away learning a lot. I appreciated that you took the time and effort to do this presentation. So on behalf of Colera, if you were in person, we would be providing you a cup. Dawn, are we sending those cups in the mail with these virtual hearings?
Absolutely.
So you should be receiving a cup in the mail to show our appreciation.
Well,
No, that's a silver mug, isn't
I
it?
thank you. Were you? I'd like to thank you all for inviting me, or at least I'd like to thank Angela Phelps-White for saying, can you do this for me? Because I really enjoy it, and hopefully that you did learn something from this that you can take back to your workplaces in terms of thinking about what your best practices are going to be for providing equal employment opportunity for your employees. So thank you.
Thank you.
Denise, thank you. It's good
Ah,
seeing you
thank you.
again.
You too. All right, take care.
Thank you.
Laura and Christine, before you hang up, if you are still online, if you could please put your CLE numbers and attorney registration number and name in the chat box one more time, I'd appreciate it. Thank you.
And for the rest of our membership, please save the date. In October, we'll be having a talk about police reform from the perspective of the police. So that should be an
Interesting.
interesting discussion. Pardon me, October 19th. Tuesday, October 19th. Same time, same station.
Okay. You're the one, you're the best, Beta.
Oh, Gary, what do you want? I know you must be asking me for something. Dawn, I apologize for that snafu on your name, but I did like Dawn Johnson and Miami Vice, so sorry about that. With that being said, I'll see you back in October 19th.
Sounds great.